Hello and welcome to Rights and Recourse. My name is Dumila Mateza. Today we are coming to you from Durban, where we are discussing an issue that should be on every South African mind with regard to personal injury and medical negligence. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse, a program that tackles issues constitutional, human rights and legal. Why do we think that healthcare, the healthcare industry and the legal profession should seriously address the issues around the cost of life expectancy in personal injury and medical negligence claims by patients? You want to take a bite?
Yes, hi, thank you. I think when it comes to the question of medical negligence and life expectancy, the key determinant on the value of any claim on medical negligence on quantum is life expectancy. If you get the life expectancy wrong, you could be facing with either an extremely low value or an extremely high value in settlement for your claim. And so often, I think that not enough time is spent on considering the key variables that should be utilized in understanding how to get to a more accurate life expectancy. It's very important for determining what the value would be of that claim.
Anybody else want to take a bite there?
If I could just also say,
all right,
as Shivesh has said, the life expectancy is the center. And we know that when it comes to compensation, we are looking at three heads of damages. That is general damages, the loss of earnings, as well as future medical costs. So the latter two, that is the loss of earnings, has to take life expectancy into consideration, and the future medical costs is also crucial.
Why I want to take up from that question. Why are personal injury and medical negligence claims based on life expectancy? Why?
No, the claim is not based on life expectancy. The claim is based on negligence or not. Once there is negligence, then you get to the question of damages. A big component of that question is life expectancy.
That's exactly what I wanted to say. That's exactly what I want. You've got to take life expectancy. Are you not supposed to take life expectancy into account?
No, that's what I'm saying. I thought that's what I said.
No, so what he's saying is that once negligence is established, if it is, then in assessing damages, life expectancy becomes a majorly important part of the claim because it is the multiplier. So if you have cost of care or loss of earnings, well, how long do you have those for? You have them for the duration of life expectancy. Without life expectancy, you don't know how long to assess those damages for.
But you must understand it's two separate processes. The damages and life expectancy only comes into play after merits have been decided against the government.
The other question I have, Ms. Goa, in a paper in preparation for this gathering, you intimate that, and I quote, "In order for us to see the change in how personal injury claims are resolved, whether arising out of the road accidents or medical negligence, there is a need to think beyond the established way of resolving these cases and find a creative solution." What exactly do you mean? Because the legal profession might not necessarily agree with you.
I don't think they won't agree. But we need to understand that personal injury law, I think it's evolving in South Africa. There are different things that we need to consider now with this. As we have been sitting today talking about life expectancy, which is, I'm sure 10 years ago, it was not a subject that was that people were concentrating on. But now, because of the fact that we've got more of these cases, so we need to find various ways of making sure that the compensation is done fairly. So one of that is life expectancy, and then looking at the other heads of damages, as I've mentioned earlier.
There's a great deal of, Dr. Kara, great deal of confusion around life expectancy in South Africa. I think earlier we were arguing about the life expectancy that has been set by the Statistician General, Dr. Padile Hodla, who puts it at 63 for women, I don't know why, and 57.7 for men. Is that something we should work around?
No. Unfortunately, that's the life expectancy at birth. And as I said, for quantum studies, you need life expectancy per year of life. So the Statistician General just gives you an idea as to the general health expectation of the country. And whether that's correct or not is another issue. But for what it is, we'll accept it as correct. But when you're working out life expectancy, for each year that you live, it affects your life expectancy either negatively or positively. If you live beyond 3 or 4 years, your highest period of death for any person is in the first 2 years of life. You're most likely to die then. Now, South Africa has a very high under 5 mortality rate. So, a high percentage of our children die before the age of 5. So if you've passed 4 to 5 years, your life expectancy is not going to be the 60 or 57 years that was given in Stats South Africa. It's going to be much more because you've passed the most dangerous period of your life. So the problem with South African life tables or Statistician General tables is they don't give us life expectancy of the older person or the child over 4 years old.
The other thing, I would want to imagine that the Statistician General takes into account the state of our health, the state of the things we do, the state of our life, the state of our economy, and all of those things it takes into account. And I'd like to go to Dr. Sulal. Dr. Sulal, talking about the state of our health, one would like to believe this is a symptomatic thing throughout all provinces, correct me if I'm wrong, that health departments, as Dr. Sfiso Mjali was saying this morning, have health system failures, insufficient medical staff like trained nurses, radiographers, and anesthetics, equipment and ethical issues within the system, lack of vehicles, all of those things contribute to a life expectancy. Are they not contributing to a life expectancy?
Health is one component of life expectancy. The other components are water, sanitation, housing, general safety, crime, education. All of those are components of life expectancy. So simply improving healthcare is not going to give you a dramatic improvement in life expectancy. It's your general standards of living that improve. In fact, if you have to take it into account, it's probably water and sanitation that would improve your life expectancy the most.
I agree with what Dr. Kara has said, but the problems we do experience, and all departments of health within this country experience, is that we get a budget that's allocated from national treasury to provincial treasury and within ourselves. The supply and demand is such that it cannot be matched, and we do not have the amount of resources that we would like to have. That is the first problem. The second part is what Andis said, that we are getting an increase in the number of medical litigation cases, and the courts of law take a long time before they resolve it. So we're looking at other measures, maybe mediation and arbitration, where we could go through these processes and not jam up the courts of law, or maybe a special court to hear it. So there's something that needs to be done, or else claims that were lodged 10 years ago are only bearing fruition now.
Dr. Kush, I seem to remember, and Advocate Dupe, you said earlier that you are not for arbitration.
No.
And in my view, arbitration is just the first step. You must take it a step further, because let's take, for instance, the case of Life Esidimeni, where there's arbitration going on now in Johannesburg. That case, that issue has been taken a step further, and that delays the time of solving those cases.
Sorry, are you talking about arbitration on the merits? I'm sorry to ask you that again. Or are you talking about after the merits? Because
Well,
arbitration, you cannot take away a litigant's constitutional right to a fair trial. And arbitration, as I said, is not cheaper, not takes probably quicker, but you normally don't have a right of appeal. And if I were a plaintiff's legal representative, I would agree to arbitration at all.
The other question for me, that's why I'm saying probably arbitration is a first step. There needs to be more done beyond arbitration, unless arbitration becomes the be-all and the end-all.
I can't see that work. I can't see that work. I can't see special courts working, because you'll have to have specialized judges. You've got such an avalanche of work in the different courts, as it were. How specialized courts are going to handle it, I don't know. So the system, I think, is all right. The problem is with the big payouts that we do not know where they go and what happened to them. If that money could come back to the fiscus, as I said, the damages that are unspent, that can go into a fund that can be built up to meet these demands in future. And as far as arbitration is concerned, after merits, it may be something to look at, but not before merits.
Ms. Goa, the other thing that I picked up from your paper was, it also points out that one of the crucial variables deserving deep engagement, life expectancy, as we already said. In other words, life expectancy is a relevant determination of a settlement value and medical negligence. Correct me if I'm wrong. Anybody can respond to this question afterwards. And especially for the road accident fund and other personal injury claim, probably an actuary, I thought I'd chase the actuary away, and I thought the actuary would be able to answer this question, but you make this point. What are these variables that you're pointing
All right, can I give that point to Shivesh, because it involves both the legal and the calculations,
Yes.
and I'm a medical.
I think definitely that point is true. Any determination on quantum has its heart and soul in the understanding of life expectancy, especially in claims where there isn't a certificate of value for future medical expenses. Remember, the largest portion of any damages claim in a medical negligence or personal injury claim is the future medical expenses. And if you cannot estimate year on year how many years it would take for that person, child or adult, to require future medical expenses, how would you calculate it? So life expectancy is that key determinant. It tells you, as Dr. Kush said, what the multiplier is. And it's so important to get that multiplier right, because if you choose the wrong variables, you could get the multiplier too low, or you could get the multiplier too high. And this is why it is central. The fact that more people don't put more emphasis on this question is very scary. Because if you don't understand life expectancy, you really have no control about the amount of money you're paying out. And this is important.
Could I just say something that the doctor said earlier about some cases taking 10 years, etc.? They don't necessarily take 10 years. But you get cases that come to court where a summons is issued after 10 years of the birth of the baby. That's what happens. I'm busy with a case now where the particulars of claim be signed by Judge Dekhan Moseneke in 1989. But they sue later on, somehow, and because of prescription that doesn't run against the minor, they can issue the summons. And that's a problem when it takes so long before they issue summons, because then you sit with a problem with records, you sit with a problem with witnesses, their recollections, etc., etc.
Dr. Sulal, how do provincial departments deal with the sheer and scary volumes of claims, as pointed out here by Dr. Mjali, from medical negligence? Because according to the PFMA, you can't budget against contingency.
Yes, that's true. When the claims are lodged with us, we first undertake an analysis. We get in the experts to see if the claim is, as we mentioned earlier, is it defendable, or do we cede liability? If it is a question of negligence, we'd not like to waste the time of all the people in the court, and we find that it is, we would cede liability and take internal processes. And undertake the necessary corrections. If we find the case is defendable, then we will proceed with the matter accordingly. As soon as we receive the claims, we also do, and we are here to improve ourselves, not only for today, but for tomorrow and for the years to come. If we find that there were negligence on part of systems, on part of the staff, or whatever it is, we then do what is a corrective action plan with an institution or within the department, or change policy if necessary. So these things are not repeated on an ongoing basis.
There's just one thing that I'm sorry, I won't talk anymore.
No, you can continue
Just
talking.
remember, negligence is not the end all and be all. Because it may be found that staff were negligent. But that negligence is not causally connected to the event that takes place. So negligence in itself should not be the end of the matter. You must go and look at causality as well. That's a second leg to the liability issue. And that's sometimes neglected, I think.
Let me talk to the psychologists, the doctors. Ethics play a very big part when these claims are made, and we've had several claims of probably lawyers making these claims and ripping off the road accident fund. My apologies, advocate, if I may say so. No, I'm referring the question to Dr. Cruz about the ethical question.
The ethics as an expert, the ethics of attorneys, the ethics overall. I mean, look, we are all beholden to professional standards. And I mean, I as a scientist am a straight shooter. It doesn't matter who retains me, the answer remains the same. I've been asked in cases, oh, you're here advocating, aren't you? Who retained you? And I said, I'm advocating for only one thing. I advocate for science, and that is my role, and that will not change. As far as attorneys, I mean, listen, I think this is weighed out in the courtroom. If they put forward a frivolous claim, then they're shot down because of it, and they will learn as a result, and there are penalties for such things. So. But as an expert, I am beholden to both professional standards and science.
So Ricardo, you're also beholden to very strong professional ethics.
What, are you saying to me or to Dr. Carr?
Firstly, as an expert, you have to abide by an ethical code of conduct. As a doctor, you have to abide by an ethical code of conduct. Now, there was a comment earlier about the rogue expert or the hired gun, so to speak. And we had a discussion on that, and we said that that's the exception. The problem with, for example, my understanding of road accident fund is that most of the cases are settled before they get to court. And then there's probably a bigger chance of a rogue expert sort of getting away. Whereas if you have to appear in court and defend a report that's indefensible, you will be exposed and you will not do it again. So maybe the road accident fund needs to decide which cases they want to settle and which cases they want to challenge. And then they need to appoint experts that would challenge the experts that they suspect are issuing reports that are not entirely legitimate. As for the attorneys, I really can't speak for the attorneys.
I've got two attorneys here. Ms. Goa, the other question for me, I don't know whether you had something to say.
No, I wanted to add something about the attorneys. I'm not an attorney, but they don't get to cases where they are not suspecting some form of liability or problems. So I always find it very difficult to understand or to take the notion that the attorneys are scavengers. They are looking for these cases. But what is key is that there is a problem somewhere. So if the department can agree on that and work on the issues as Dr.
Sulal.
Sulal has said that they have to go back and try to improve the systems. But the attorneys themselves, we know they are all, I think in most cases, they take a case when they think that there's a potential for some negligence. Then it's up to the government now to actually fight it and actually understand or unpack the case and see and agree or disagree about the merits of the case.
We've got two attorneys. We've got an advocate and an attorney. Probably they should put the case forward around this. We are not tarring everybody with the same brush. We know there are very good attorneys and lawyers and advocates. What is your experience, Dup?
If there's such a thing as libel, so I can't give you a straight answer. Let me say this, we have experienced people where, you talk about the Texas Texan sharpshooter, you know the story? Where Texan goes to a big barn, paints a big circle, he fires at random into the wall. And then he goes, he paints a circle around it, and he says, bullseye. Now, many people, experts, go and say, for instance, HI. If there's HI, I've heard people say that in evidence. Well, the mother went in, she was healthy. Baby was healthy. Comes out with CP. Ergo, negligence. That's nonsense. But those are opinions, and it's difficult to take, I suppose, them to their boards. What you should do is, if that is what they do, prepare it properly, show them up in court.
Do you want to comment on that?
Exactly. That is what I said. Is if the report, if you consider the expert report flawed, you've got to challenge that expert in court, and your advocate and your expert has to prepare adequately to challenge each point that expert has made. That's the only way to identify and expose an expert that's perceived to be biased.
I've heard another question, another issue here, that obstetricians are loath to deliver babies because they are afraid to be sued. Is that a case? Is that true?
Yes. Well, certainly in the private sector, many of the obstetricians are facing phenomenal claims for malpractice insurance, and currently they claim 800,000 rand a year, and it's late in the afternoon, but I don't know my math, but that works out to at least about 60,000 or 70,000 rand a year, a month. That means they've got to do, let's say they charge 7,000 rand a delivery, which they charge more or less, whatever, but that means their first 10 deliveries of the month is only to pay their malpractice insurance. And they're restrained by the economy as to what they can charge patients. So it then becomes not economically feasible for them to deliver babies, and then they stop delivering babies, going to gynecology and consulting, and in so doing actually end up with a more profitable practice with a far better quality of life.
There's an American article that I'm so sorry, that I used in court. I think it was around about 2010, thereabouts. Peer-reviewed article. The heading was, "Who is going to deliver our grandchildren?"
As we review our statistics, and we've done some research of our own, we have found more than a dozen obstetricians in and around this town have stopped private obstetric practice for the reason, as Dr. Karas mentioned, the contribution to the medical, legal, or medical defense union or protection society has become too astronomical for them to manage. And it is having an impact on state, because some of those patients are finding alternative obstetricians, but some of them are then returning to state The other point that Dr. Kara has mentioned, because of this huge cost, the increase in fees is not affordable by all the patients, so they have no option but to come to the state. So it has put an impact on the system. And my concern is that there are less and less doctors now willing to specialize in obstetrics and gynecology because of this huge medical legal litigation cost that is put on it.
The strange thing is, you know, you're going back to midwives.
Wasn't it a good time to have midwives?
It was a good time.
The system collapses at some point. I mean, the pressure on OBs, I see this in the States too, is that, I mean, look, there's two things that stresses people out a lot, and that is getting sued or getting sick. And at some point, if the system collapses, then there will be reform. That's the ultimate requirement, because if it's not done beforehand, then it will just ultimately collapse, and then you'll have reform. But it's too bad that it can't be done ahead of time.
Ms. Goa, I'll come to you, Chief. Ms. Goa, I just want to ask this question, Ray, based on this answer that Dr. Kush gave and Dr. Sulal gave. The government, after '94, did away with nursing colleges. We had those nice nurses. I'm reminded by the midwife story. We have those beautiful nursing colleges. Do you think that something like that has been brought back into the system?
It's a very difficult question, but if I can answer it at a lay level as a lay person, because I need to find more facts. But what is clear is that there is some talk of the nursing schools that are producing sub-minimum standard. But I cannot be the person who quantifies that, but there is that talk, and it really affects the system.
Chief, the other thing for me, Dr. Sulal here, we spoke about the avalanche of cases that reaches their office, people claiming against the state. Is it a matter of people are becoming more and more aware of their constitutional rights?
Yes, and I think that's a good thing. It comes back to that same question, well, are attorneys to blame? No. People are becoming aware of their rights, and they are acting on their rights, and that means that there's more litigation against the state. That's one part. The second part is that those persons who are involved in the defense of these cases need to get more educated. Whether it comes to a question of negligence, whether it comes to a question of causality, or whether it comes to a question of damages, there's no point in us being upset about the fact that there's such high value in claims when people are not exercising their right to information in learning about how to defend these claims. And this is the purpose why these gentlemen are sitting here, is because if you can ask me, well, is life expectancy the key determinant in understanding quantum, but we're doing it 10 years after we hit the avalanche of medical negligence claims, then that's the problem. The problem is we should have started this ages ago. We don't have statistics in South Africa that indicate to us what the life expectancy of a compromised person is. We can't determine to what extent the multiplier must be reduced. But we still complain that the values are high. There's no correlation there because we should act now and we should act fast.
You reminded me there's some issue you can first answer to what I just want to put this question in. There's an issue that South Africa doesn't have the data. We have to rely on data from California or from the United States. Whose duty is it to collate this data?
It's the government. It's the government's duty. In the past, if we go back to the medical legal litigation and even before that to the Road Accident Fund, these problems have been going on for years. They're not recent problems. Despite all these problems, aside from a few populist comments by politicians, what has tangibly been done to reduce the risk of malpractice suits in the government sector? What tangible processes has this government done to minimize their risk? I don't see any evidence of anything being done. Yes, you may get local hospitals doing sort of self-motivated processes, but there's no coordinated national directive to minimize the government's risk to healthcare incidents. As an example, if a nurse is negligent, you can't fire her with the present labor laws in this country. So how do you send the message to your staff that if you've applied for this job, you have to fulfill this job? And if you don't fulfill this job, there will be consequences. How do you do that in South Africa? You need a committed government will to direct its management and its staff to conduct healthcare to its patients in an appropriate manner. And despite your best efforts, yes, you will make mistakes, but at least you will minimize them.
Mr. Goa, I interrupted you. You wanted to say something earlier.
No, I was going to echo exactly what Dr. Karayev said, in that there are two approaches that I think are crucial in managing the rise of the medical malpractice cases. One being preventative from the government side, and looking at what can be done by the government in terms of managing these claims, and also looking at the human resources and the other problems that they have related to resources. And then the second part is that we know that there are cases that are already on the pipeline. So with the cases that are already on the pipeline, there has to be a plan to manage them. In terms of analyzing the damages, starting from the liability level and ending at managing the actual damages. Because I understand the contingent liability for this in KZN, I think is quite high, and I'm sure the doctor can actually give us an indication of how much is that. But those are only the cases that are on the pipeline. But what do we do to prevent all of this?
Yes, Dr. Sulal, yes, I heard Dr. Mjali mentioning a figure of 10 billion rand, and I don't understand how does Treasury allow you to put aside to budget 10 billion rand when something has not happened yet?
I think Dr. Mchali is referring to the cases we have from 2008 to currently amount to approximately 1,500 cases. And that is the summons amount that we received amounts to about 10 billion rand. Then we go through, as I said, sift the cases out, and then we, as my honored senior counsel says, that we first argue the merits of the case, and when we concede liability, we then look at quantum at a later stage, and then it's debatable. Life expectancy is one of the issues that come, because it is, as my previous speakers have mentioned, it's that amount times that number of years. So it's really important. You know, if you're born with a kidney defect or diabetes or whatever it is, and your life expectancy is decreased, it depends on that period. In this cerebral palsy, as a result of medical negligence or whatever it is, it could go to 30, 40 years, and it's a huge amount running into millions of rands. As the government, I think we are aware. We have, the national minister has an advisory team that advises him comprised of government specialists and the private sector. We all at various provinces have the so-called medical legal units that are going in, where we not only look at it, we're looking at the preventative measures, we're looking at how we can correct it, we're looking at empowering staff, we go out to institutions and regions and share what were the problems. At the same time, we are training staff on a thing that they've never been trained for. Medical staff are trained on medicine, but we have to teach them also on how to write a medical legal report, have to educate them on what the various speakers said this morning is in their panic and in their stress not to alter records because they make a mess of it, how to correct these issues. There's a lot of training, there's a lot of empowerment. Yes, there is consequence management. We try to empower people and correct the issues. We have, governance structures in place and performance agreement. They can't go on making the same mistakes. When we do analysis, they're done per institution, per district, per area. What are the causative factors? And I think my HOD mentioned this morning, there are a lot of ancillary factors that go on. You know, it's the EMS, the shortage of vehicles that we have to do, it's shortage of staff, and as you're aware, if you have to spend, and I'm sure many of you have spent some time, you have to spend some time in state hospitals, and some of the huge ones, where we do 1,500, 1,600 deliveries, and it can be really terrible. And when we talked, and Dr. Kush talked about record keeping, and you know one of the problems with doctors is you're really busy at night and you swept off your feet. You don't have the time. You can't sit and write the record when the next patient needs your attention. It's very easy when we have to look at things retrospectively, proactively on your feet there. You take that decision, and that decision is life and death. You got to be quick and on your feet. While you're doing that, there's others calling you, there's queues waiting for patients to go to theater. There are other emergencies. It's a whole multitude of factors. It's not an excuse. But we got to learn to write, because we don't say, we say patient for cesarean section. There's no way we write there's 6 other cases waiting to go for theater. The available theaters in the hospital are 2. There's a stab heart in 1. What do you do? We need to write, to learn, to correct ourselves. And as the HOD said, that we are starting to over-investigate patients, or maybe we're being on the defensive. So,
if you'd like to join us on Rights and Recourse, you can tweet us at Rights and Recourse and give us your comments. Also, you can email us on rightsandrecourse@sabc.co.za. Stay with us.
The government is caught napping here by the medical negligence. It is under siege, every province, because the government is found wanting of its failure to perform the constitutional duties that are enshrined in our South African Constitution. And we're at a tail end because we are seeking to redress damage after a failure right at the entry point. The entry point being, at the hospitals, there's a serious shortage of personnel, of expert people, knowledge people, the experienced people, shortage in personnel, shortage in machineries, shortage in experts to render quality health services for South Africans.
I think it certainly opened up a discussion around the issues. Some issues, yes, we have discussed because we had various people from the Department of Health, we had people from the Department of Justice, we had the Road Accident Fund here, and we started a conversation. So some issues were answered by our experts on life expectancy, for example. It was clarified why we use American tables in a South African context. I certainly think there are a lot more issues that may have come out of this, and it's opened up a discussion which I think is ripe now. We need to have the discussion, and we need to find the solutions in a South African context.
Dr. Kush, you were challenged to help South Africa with this data issue. Have you taken up that challenge?
Absolutely. I have been very happy to be out here. This is my second time to South Africa in the last month, and I love the country, and I am happy to return and help train, help gather data, help rally the troops, whatever I can do. I really believe it's such a critical issue. And I believe that it seems like there's a crisis, a real crisis, and I would be happy to help.
What crisis? The other question, I was intrigued by one of your slides. On one of your slides, there was a writing, and I felt a little bit, my heart pumped a little bit harder when I saw the need for fairness for all. What did you mean by that? You didn't talk about it.
Well, absolutely. Fairness for all, I was summarizing what Dupe had covered in his talk, and I really wanted to echo that. Fairness to all means a number that's not skewed, a number that's based on reality and not unfair, meaning too high or too low, because it can be unfair to both the defendant or the plaintiff. And I just, as a scientist, everything is about fairness.
Let's take a question from the floor. Mr. Sushuba, you have a burning question. You have a microphone with you. Let's wait for the microphone to get to you before we take your question.
Mr. Matters, really, all that we are going around there, as the panel is the question as to what are the citizens' rights in relation to the issue of the life expectancy that then determines the rest. First of all, we must understand that that question comes after the issue of liability has been settled. For example, if this is now, as this usual happens in these government cases. A question, Mr. I'm going to answer a question. Look, we must understand the context of the question and the clarity that I'm getting to.
Based on Section 27 of the Constitution.
Well, before that, the matter is already in court. Somebody, the department has been found to be liable. Then the issue now is to what extent must then be compensation? This is where life expectancy comes. Stage 2, Mr. Mateza, must know these things. Yes. Then what normally happens then, there's two issues now. You must prevent undercompensation and you must prevent overcompensation. This is exactly then where the issue of liability and life expectancy becomes relevant. General damages will be paid because it's easy, case law explains. It's very easy to deal, it's very difficult now to deal with future damages. Those future damages being medical expenses and caregiving. This is exactly then where these experts come into place into determining that amount.
Let's get a view from the panel here about what you have raised. You've raised very good questions, which I did not have sight of. The one aspect, Dupe, let me come to you. Probably you can answer.
What is the question?
The question is, how do you then quantify the damage? For instance, I got something here, there's compensatory damages, there's monetary loss, there's non-monetary loss. How do you place those things in a context?
What you mean, that's now after liability, as I've said, and as Advocate Schubert confirmed. Well, you deal with what everything has been going on here this morning. You lead evidence as to the condition of the child. You get the experts to say what the child needs. If there's no agreement, you lead to one expert after the other, sometimes 20 of them lined up. And then, if there's no agreement, then the defense have to deal with that. And it's our duty as advocates and officers of the court, with the duties towards our clients, is to guide the judge towards a just order for compensation.
Can a court, let me ask this question, can a court use a precedent in awarding damages?
They do use precedents all the time, but they also say that it's very dangerous to just use your precedents without looking at the specific circumstances of the specific case. Precedents in this kind of thing is normally guidelines. And so, yes, they look at it, but they will reiterate that every case depends on its own facts.
Dr. Sulal, earlier you mentioned that you do settle even before a case goes to court, but where does the money come from?
Let me answer the previous question before I come to this. I think it's very clear that when we meet, experts from both sides usually agree to a joint report to the judge. And if there is no agreement on a joint report, then it is debated and the court comes to a decision. Is once both sides agree to this is the future plan and treatment, and depending on the life expectancy, then the quantum calculation goes. When I talk about mediating cases and others, the money will come from the same source as where the money is coming now, and that is from the provincial treasury, as the PFMA doesn't allow for contingency liability for this case. However, it is something that we are still investigating and going to try pilot cases now and obviously get feedback from all concerned. It's just that we want to try to find a mechanism that could be quicker and not prevent blockade of the courts. But we hear other opinions here, and I'm sure this matter is now being investigated by the Law Commission and others, and various, I should say, public hearings and others will take place as soon as we have our recommendations in place. The other issue is that where will the money come from? It will come from the same source that we are obtaining it currently.
All of these problems, probably, let me ask the medical people, all of these problems that we are encountering and we're talking about here today, obviously should lead us somewhere. And the minister has been, and the government has taken a policy view that the NHI is going to be introduced. Are we ready to have the NHI introduced?
The NHI is a nice pipe dream for the future, and it fulfills a very nice political will to, I mean, who wouldn't want improved healthcare for everyone in the country?
Well, it's like the National Development Plan.
Yeah, I mean, it's a no-brainer. Everybody wants improved healthcare and free and easily accessible healthcare for its population. The problem at the moment on NHI plans is that white paper a reasonable indication of the sustainability of the program? We have a government at the moment that has its private, that criticizes private hospitals for being expensive, but doesn't address the inefficiencies in its own hospitals. And in some ways, it then says that by destroying or stopping access to private hospitals is going to improve healthcare for the entire country. Now, is that just a politically convenient statement to make, or is that a genuine attempt to improve the healthcare of the country? Then there's the cost of NHI. Anything that is free to a member is open to abuse.
Let us take another question from the floor. This gentleman here, oh, that gentleman with the mic already.
Thank you. Mine is a follow-up on what we debated in the morning session. Dr. Kara, you'll remember, I said now there is a judgment where an expert is described or labeled as a hired gun. All I am asking, and I know what our duties are, all I'm asking is there a mechanism in the medical profession that is in place in order to deal with witnesses like those? Because it's not good to have witnesses moving around our high courts saying that they are experts and giving incorrect medical statements. That
you are Mr.
Kunju, Advocate
Kunju. Thank you very much, Mr. Kunju. Mr. Kunju is referring to something there which we normally talk about. I think courts have something called perjury, don't they? Do one perjury work in that case?
I don't know the legal aspect, but if you were to say, what can the medical profession do about this doctor? You can report that doctor to the HPCSA. My experience with that route is nothing much is going to happen. And I know I'm on a public forum and I'm saying it exactly as it stands. So I don't think on a medical aspect there's anything that can be done about the so-called hired gun. I think the only way to take him down is on the legal aspect of issuing a false opinion.
Let me come back to Ms. Goa and Shiv. You, I think in response to the challenge that was given to Dr. Kush this morning or this afternoon about helping South Africa develop this data, you were saying you are putting together a white paper. What is the actual aim of the white paper?
I think from our perspective, the aim is to, one, understand the crisis that sits at the foot of not having data, and two, to get the motion in play of creating a plan where we get the data. If somebody, and I know you asked Dr. Kara who's responsible for the lack of knowledge in life expectancy in compromised individuals in South Africa, and Dr. Kara said, should it come from government? But we are not government here today. We are private citizens. We are in the private sector, but we are still shouting out that this is a problem.
Isn't that what should happen? That something like legislation should start with you and me?
Well, what it should start with is a conversation. And this is what we're doing. What we're saying is that the situation is so dire. If private sector have to shout to government, you are in trouble because you're not seeing this.
Dr. Sulal is burning to answer.
Yeah, I think, having noted the last speaker and others, thank you very much, Dr. Kirsch. I think from the government side, and I don't represent them here, but I work for them, I am sure we could fast-track your ability to train life expectancy experts in this country and link you up with the various national ministries and get their buy-in and, I should say, fast-tracking of the mechanism. As a country, we need
I would be happy to.
And we are proudly South African, and to improve ourselves, we would walk the extra mile to get your assistance. We appreciate your assistance and correct it. I think it's not only for life expectancy experts. We have been taking all your comments today. We've been at opposite ends of medical litigated cases, but we've learned from it, and we are starting an intensive prevention and corrective program. Hopefully that it won't be there in the years to come. It's made us better people, and really, we want to improve as a country. We've identified it 4 or 5 years ago, and to see somebody of your caliber come here, we would walk the extra mile, arrange with our heads of departments and our MECs to fast-track it to national, and really, we would welcome that assistance. So I think you are more than welcome.
30 seconds.
30 seconds, I'll pass out before then. But data, where do we start? I mean, we're all talking about data. Where do we start?
Start from scratch.
Why can't government go and appoint people to follow up on the cases that have been settled or paid out, see what the life expectancy was, and see what happened to those children? You've got to start somewhere. Now, I know it's going to cost money, but it's going to save money in the end. And shouldn't that happen immediately or as soon as possible?
Easy. Let's get a final word from Ms. Gower. Final word.
Yes, yes. I was going to agree with Advocate De Bruin that we need to start somewhere. There are so many resources, I think. Apart from the actual litigants, there's also other organizations like the Schools for Children with Cerebral Palsy. There's a lot that we can consider to collect all this data. But we must know that it cannot be a solution that is going to be available in the next year. Because if we have seen the Californian data is many years of collection and looking at the cohort or the group for a certain period. So we need to start somewhere as South Africa. And I'm so happy to hear to get the commitment from the government that we are going to be doing something about this, because we've been shouting and we've been out there saying we need solutions. Let's come out, let's talk, let's try to solve these problems, because it's not only the government's problem, it's also our tax. We have to be responsible. We need to be responsible citizens at the end of the day.
And also, I just want to add, apart from that, why can't we lead? Why can't we? Why must we always see ourselves as the ones suffering from a problem? We are all intelligent. This is the fundamental thing that's present whenever I look at a matter. If it's obvious that it's a problem, we are intelligent enough to find a solution.
Ladies and gentlemen, thank you very much for your time. It's been a riveting discussion. I know we've had a long day. I want to thank you for allowing us to take 40 minutes of your time and do another program. This has been Rights and Recourse. This program is repeated on Monday morning at 5 o'clock. Please do join us again. From all of us, with our friends, thank you to our guests, and good afternoon.